Hello, you are a tenant, whether it's a home or an apartment, and you have received a notice to vacate. When should you consult an attorney? That's what we'll be discussing today. Good morning. My name is Benjamin Sanchez, and I'm an attorney in Houston, Texas. I defend consumers, tenants, and homeowners during life setbacks so that they can move forward. Today, I want to discuss when a tenant who is facing an eviction should consult an attorney. There are three different times that are natural points in the process that a tenant looks for an attorney. The first time is when they get a notice to vacate, but prior to any eviction lawsuit being filed. The second time is after an eviction lawsuit has been filed, but prior to any trial at the justice court. And then the third time is when they have lost the eviction trial at justice court and either need to appeal or to the county court, or they've already appealed to the county court, but now they need an attorney because it's a bigger court with lots of rules that they need to follow. So those are the three natural times that a tenant naturally looks for an attorney during the process. Unfortunately, what I've seen is that most tenants wait until that third time to do it. They wait until they've already lost the JP court trial and they have to appeal, or they've already appealed. And by that time, they have not necessarily not allowed me to do my job effectively as a tenant attorney, but they have reduced my options to help them. The best time to hire, or at least to consult an eviction attorney, is when you get the notice to vacate. And in fact, I will tell you that just recently I had someone retain me as soon as they got a notice from an attorney. And what I was able to do was be able to send that attorney a notice of representation so that the landlord or the attorney no longer talked directly with the tenant, and it took that weight off of the tenant. And then I was able to talk to the attorney one-on-one about the legal issues and about the factual issues so that there wasn't a rush to the courthouse. So not only was I able to delay the process, but we're still coming up with a solution, but at least the solution is not going to involve some sort of actual eviction. The worst thing you can do is what I told you from day one, is not respond. The second worst thing you can do is wait until you've lost to hire an attorney. There are things that you can do at JP court to potentially win or have the case dismissed and have them start all over again, which also gives you an opportunity to negotiate with the landlord to try to stay in the home or apartment that you're located in. Once you appeal, the problem is that sometimes the appeal is not done correctly. There are certain rules that must be followed in an appeal. If you are appealing without a bond, there are certain things that you need to pay within a certain deadline. If there's a contest upon your statement that you can't afford the appeal bond once you've lost, there is a certain deadline by which that hearing must take place. If you hire me or any other attorney by the time you get to county court, you may have already screwed your case up so much that the judge in the county court is forced to dismiss your case. So again, the best time to hire an attorney, or at least to consult with an attorney, even if you don't want to hire an attorney, is right when you get the notice. because most people don't know what their rights are. What I'm trying to do with this video series and what I've tried to do this week is to give you enough information that you are aware that there may be some issues with how a notice to vacate was delivered, what contents it should have, and whether or not it was screwed up. And as long as you are aware of that, then at least when you consult an attorney, you can say, hey, I may have a defense, but I need to hire you to be able to talk to the other attorney. So that's all I have for today. Again, 3 times, the worst time you could do it is when you've already lost. I know a lot of tenants don't want to pay for an attorney up front. I'll leave you with this. What I tell tenants is this: do not pay your rent after you have received a notice to vacate unless you have a written agreement that allows you to stay in and move forward with the lease. Too many times I have seen a landlord take the rent but still proceed with the eviction. And unfortunately, that is legal in Texas. So do not pay the rent. If you have some money and you've received a notice to vacate, quite frankly, you might be better off spending a little bit of that money to get with an attorney to make sure that you are protected if you're able to stay in there. And quite frankly, if the landlord is not going to work with you at all, then and you have money, then quite frankly, you have enough money to hire an attorney, because that rent money that you normally would have paid can then go to the attorney. But really, what I'm talking to you is about is consult an attorney right away, because that's the best time to protect you. I hope you all have a great weekend. I hope you enjoyed this week. I will be back on Monday, and I think I will cover maybe a different topic. I do a lot of debt defense cases, and so I think next week I'm going to talk a little bit about creditor lawsuits and how you defend against debt lawsuits, which are not limited to JP courts. And there is a big difference between a justice court and a county court and district court in terms of the rules and discovery and procedure. So I think that's a very important series that I want to be able to do next week, is some of the basics about debt defense. I hope you all have a great weekend. Again, this is Benjamin Sanchez. Feel free to like and share this video and follow me if you want to. Have a great day, everybody. Bye-bye.